Hi, this is Howie Slumka at My ATL Law, and clients and prospective clients ask all the time about the difference between a wage garnishment and a non-wage garnishment. So let me back up first and say that a garnishment is only relevant after your creditor has a judgment against you. If they say that you owe them money, and you know that you owe them money, and you're afraid that you owe them money, it doesn't matter. The only time they can get a garnishment against you is after a judge has ruled and issued a judgment that says that they owe you the money. Now that happens usually in the form of a default judgment. After all those years of asking you for money, they might have sued you and you might have ignored it, and then they have a default judgment. When that happens, they can do two types of garnishments. They can go after your wages, or they can go after your bank account. Now many clients are confused about, well, what happens about notice? Don't they need to tell me we're doing that? And unfortunately here, the law makes a lot of common sense. They don't need to give you notice that they're going after your bank account, because if they did give you notice on Monday that they were doing that, you would withdraw all your funds on Tuesday. And that's not how it works. They have the right to withdraw the funds. When funds are taken with a non-wage garnishment, they are placed in the hands of the court. The creditor doesn't get them yet. The court will hold them for 30 to 90 days, and during that time period, you can file what we call a traverse, you can answer, or you can file a bankruptcy and get those funds back. So come see us. There are limits, of course, and there are some funds that are more vulnerable than others. But in general, if you owe a lot of money and you have money in the bank, please don't assume that it's safe. Your judgment creditor, without your knowing, can sneak up on you, file a non-wage garnishment, and freeze those assets.